feel the need to address a few points that have been made in this discussion today. I want to start with the argument that has been made aggressively by some members of our committee today, suggesting that Judge Barrett shouldn't be confirmed because she criticized Chief Justice Roberts in his analysis of the Affordable Care Act in NFIB versus Sebelius. It's a dangerous thing to suggest that the court is above reproach, that you can't engage in analytical debate surrounding the appropriateness of what the Supreme Court has done. Look, this is not some fringe viewpoint out there. This is a legitimate argument. In fact, I state unequivocally it is the correct position. Chief Justice Roberts rewrote the Patient Protection and Affordable Care Act, not just once, but twice, in material ways in order to avoid two separate, freestanding, independent constitutional defects that would have taken down the whole law. Now, look, he did it. I felt so strongly about it at the time, I wrote a book about it. All 12 people who have written it have said it was a stimulating read, and they really enjoyed it. But it was therapy for me. The Commerce Clause is real. It's a big deal. You can't exceed your authority as a Congress under the Commerce Clause and then expect the Supreme Court of the United States to rewrite something as a tax instead of a penalty, such that it can be analyzed under a completely different framework of constitutional analysis. Now, look, I understand that you disagree, and you have every right to do so. A lot of us, most of us, I think, in this room are lawyers, and I think people of high intelligence can reach different conclusions about this decision. But of all the reasons you can think of to confirm or not confirm a nominee, I don't think criticizing a narrow 5-4 majority, or even the author of that narrow 5-4 majority, who blatantly rewrote the law in two material respects, thus betraying his judicial oath. Now look, I don't purport to know what drove John Roberts to do that. What I do know is that whatever drove him wasn't the law. He had to rewrite the thing twice. That was wrong. Insofar as anyone here is suggesting that criticizing the legal analysis employed by Chief Justice Roberts and NFIB Sebelius somehow disqualifies someone to serve on the federal bench at the Supreme Court of the United States or otherwise, insofar as they're suggesting that this reflects a lack of humanity, a lack of compassion, or even a policy view about the appropriate role of government in general in healthcare, or what kind of healthcare system would be best, are missing the point. The Supreme Court's not a policy-making body. I understand some of what they do there implicates policy. But look, to tell stories about people who have benefited from the Patient Protection and Affordable Care Act, and to use that as evidence that any jurist shouldn't be appointed to the Supreme Court of the United States, it's not fair. But more importantly, it misapprehends the judicial role. We're not looking for someone with the most compassion. We're looking for someone who interprets the law based on what it says, rather than on the basis of what he or she might wish it said. And to tell stories of a mother with a child with Down syndrome, suggesting somehow that Amy Coney Barrett lacks compassion for children with Down syndrome, is patently absurd, given that she has a child with Down syndrome. Whatever your view of textualism and originalism, whatever your view of canons of statutory construction or of constitutional interpretation, I'd like to hope that we can have legal discussions on a sound, rational basis without accusing each other of not caring about the poor and the downtrodden. Amy Coney Barrett's got 7 small children who can tell you that she cares a whole lot about feeding the hungry and clothing the naked, that she has basic compassion. So look, go after the timing if you want, go after her judicial philosophy if you want to, but I don't think what you're saying is fair. But more importantly, I think it sets up an unsustainable, irrational, counterproductive, and indeed harmful expectation about the role of the federal judiciary. It's wrong. What you're saying is wrong. The way you treated Brett Kavanaugh was wrong. The way you treated Neil Gorsuch was wrong. The fact that you brought up a case in which there was an individual who didn't get the relief he wanted because federal law didn't authorize it. And many of you on this committee accused him of being a heartless jerk because he didn't rule in their favor. That's wrong. I'm not saying that anyone who disagrees with me is wrong, but I'm saying you can't couch this in terms of compassion. Alexander Hamilton meant what he said, and he said something profoundly true in Federalist 78 when he explained that there is a difference between will and judgment. Will is what's exercised by a legislative body, a political body, a policy-making body like ours. Judgment is devoid of will. And if the judicial branch starts to exercise will instead of judgment, it messes everything up. It's especially harmful when you say that this indicates and reflects a lack of compassion, and that lack of compassion, as you deem it, somehow disqualifies someone for judicial office. That's wrong. As for your suggestion that one cannot reasonably question a Supreme Court ruling, whether authored by the Chief Justice of the United States or otherwise, flies in the face of what I think we all believe. The Supreme Court is not infallible. It's not deity. To suggest otherwise, as you do, would be to suggest that nobody could have in their right mind been critical of some of the worst decisions in Supreme Court history. We can name just a few, including Dred Scott versus Sanford in 1857, including Buck versus Bell in 1927, including Korematsu versus the United States in 1944. There are endless other cases, some of them high profile, others not high profile. Some of them really bad, some of them just sort of bad, where the Supreme Court has gotten it wrong. It doesn't make someone lawless, and it certainly doesn't disqualify them from serving on the Supreme Court of the United States to be able to acknowledge that there are bad decisions. Or, heaven forbid, to acknowledge that sometimes the Supreme Court of the United States gets it wrong for matters of policy, as, by the way, the Supreme Court did in the 1905 case of Lochner versus New York, wherein the Supreme Court cobbled something onto the Constitution, nowhere in the Constitution, that said we really don't like these minimum wage, maximum hour laws imposed by the state of New York on bakery employees. So, due process, screw it, we'll get rid of it. That's not okay. You wouldn't defend that. I don't think any of you would defend that. But to criticize someone for questioning whether the Supreme Court did in that instance shouldn't disqualify someone, and the recency of this bad decision, this 5-4 decision, that I can tell you as a former Supreme Court law clerk is written in a way that strongly reflects the widespread belief that John Roberts flipped his vote at the last minute, just like Owen Roberts flipped his vote at the last minute in 1937 in NLRB versus Jones and Laughlin Steel, probably in support of some greater good, as both Justices Roberts concluded at the time. That doesn't make it right, but it sure as heck doesn't make it beyond reproach, beyond criticism. And that doesn't mean that anyone who criticizes those rulings can be found unfit to serve.